Okay, this chapter is on the federal courts. So Article 1 is the legislative branch. We went over that. Article 2, which I just filmed that video on, the executive branch is the presidency and they enforce the law. So Article 1, legislative branch, they make the law. They also control the money. The executive branch, they enforce the law and they control the military, the police power. Which would include also like the FBI and law enforcement. The judicial branch interprets the law, and so they have the power of the pen. They decide what's constitutional and what's not, which actually would seem the weakest of the three powers, but it also can be pretty powerful and pretty important because they tell what is allowed and what is not. They make the rules. And they serve as an important check on the powers of the legislative and the executive branch. As I just mentioned in the previous video, it is up to them to determine what an executive order is okay and when it's not. It's up for them to determine when Congress passes a law as to whether that law is okay or not. So it is really important. And it's part of this brilliance of this separation of powers, which was first argued during the Enlightenment by Montesquieu and then became a part of the constitutional system that we have. So some more about the federal courts. Again, this is just an introduction, these videos, so I can't teach it all, but I like to try to teach some of the big important concepts for which there's big misconceptions. One of the big misconceptions is people get upset about judges and they'll be like, these judges are not elected and they're not accountable to the people. We need to start electing them and things like that. Well, there's a big problem with that because judges are not supposed to do what's popular. They're supposed to do what is constitutional. Especially federal judges. They're supposed to interpret what is in this document, the Constitution. So when they're deciding cases, especially if we talk about controversial cases with affirmative action, death penalty, abortion, so forth, or any case, it's not supposed to be their personal ideology or opinion. It's supposed to be whether this Constitution permits or doesn't permit it. Obviously, their own bias and personal prejudices is going to come into play because those things always come into play. But that is what their chief responsibility is. And if justices are issuing opinions just based on popularity, then they're not going to do what's constitutional. They're going to do what gets them reelected. And that's not the point. If that was the point, they would have never issued the Brown versus Board of Education decision integrating schools because they would have all lost their job. They all not been reelected because that was a very unpopular decision. Same for Loving versus Virginia, the case that banned, that overturned laws that banned interracial marriages. Very unpopular at the time as well, and gay marriage as well. It was up to the court to say, no, you can't discriminate. That's another thing, is the courts are here to protect the rights of Americans, because sometimes Congress will pass laws and states will pass laws that trample on people's rights. And the court is there to step in and say, no, you cannot do that. And we see that happening time and time again. More recently, you see Oklahoma and so many other states that are passing laws that really discriminate against LGBT, particularly more recently trans. And I expect those cases are going to go to court. And even with a conservative court, the court, although more recently the court is hearing a trans case, and they sided with the state of Idaho more recently on as far as trans treatment of children go. But nonetheless, that's something that is currently before the courts as well. Something else you're going to read about and study about as you study the federal courts is you got the full appellate court system. Our federal court is in Muskogee, our district, and then that's our federal court, Muskogee. I actually served on a jury trial there once. And then the appellate court is in Denver, Colorado for this district. And then the ultimate arbiter is the Supreme Court of the United States, what's sometimes called SCOTUS. SCOTUS does not hear that many cases. Most cases will never make it to the Supreme Court because it's got to be something that has not been decided. It has to be a pretty big deal, something that they're unsure about. So, for example, with gay marriage, you actually had some courts that were ruling that gay marriage was protected and that states can't ban it. And you had other courts that were saying that states could ban it. And when you have that, then the Supreme Court better step in and decide. And so those are the type of situations where court steps in. And we hear the court right now, it's hearing cases. Some of those cases are related to Trump because he's tried to argue presidential immunity. That case is being heard. A lot of different cases. So that means that whoever's on that court of the 9 justices, that's going to be really, really important. People have talked about adding members to the court because nothing in the Constitution says there has to be 9. Historically, before the Civil War, they had, I think, like 5 at one time and maybe more. But really, in the 20th century and after the Civil War, basically it's been 9. And so that means that nomination process and that confirmation process is important. The president nominates, and then the Senate confirms the candidate or decides not to confirm the candidate. And that's the subject of your assignment this week. It is about that nomination process, which used to be bipartisan, and it used to be where Democrats and Republicans would come together and be like, okay, is this person a good person, an upstanding citizen? Are they qualified? Are they, do they have the legal background to be a Supreme Court justice? And are their views pretty much in the mainstream, left or right? And then they would approve. And it used to be nearly unanimous, or, and then on the rare occasion, if a candidate was seen as not being qualified, especially with federal judges. Since the Bork in the 1980s, as you'll see in the film, and then going with the Thomas hearings, who is still on the Supreme Court in the 1990s, then they have become much more contentious. And if you haven't paid attention, Trump got 3 appointments in his 4 years in office. And part of that was because right before the election, Ruth Bader Ginsburg had died. And, first of all, right before the 2016 election, Scalia had died, and McConnell said, we're not gonna do anything with that. We're not gonna appoint anybody. And you'll see that in the video, and I don't have time to explain it now. But my point is, it's become hyper-partisan, meaning it's become very, very political. I think it's undermining people's trust in the court. And the reason it's undermining people's trust in the court, because people used to think of the court as not being Democrat or Republican or being political, but just trying to make decisions based on the Constitution. And now people are viewing it more, well, you're picking these candidates more based on their ideology than on their qualifications. And I think that's one of the points of the film that you're going to be watching and learning about. So I had a lot more to say, but my time's almost up, and I do try to keep it under 10 minutes, so I'm just going to wrap it up there. And we only have one more chapter, and I think that one is on foreign affairs, and I'll introduce that next week. So as always, email me with questions.